Thank you. So today I've been asked to speak about fire engineering 2026 and beyond, and I'm really grateful to have this opportunity. I do hope there'll be time for some engagement, so looking forward to some questions after my presentation. Before I start, I'd like to acknowledge the traditional owners of the land on which I'm sitting today. I'm in Melbourne, in Victoria, and I acknowledge the traditional owners and pay my respects to elders past and present, and to all Aboriginal and Torres Strait Islanders people on this call today. Now, just bear with me for 1 second because I've got a big thing up. It's sitting, there we go. That's going to be better. Chuck that down there. Okay. So today I'm going to talk about legislative changes affecting the fire safety engineering profession, and I'm pretty much going to focus on what's happened since the Building Confidence Report. I'm also going to look at what courts have said about the role of fire safety engineers, political and market forces, and the future of fire safety engineering in Australia. And as Josh mentioned, I'm not a fire engineer, so I don't profess to make this presentation with any technical knowledge, but I have read literally hundreds of fire safety engineering reports associated with cladding. In one of the roles that I had for a few years at least was to be involved in matters before Victoria's Building Appeals Board, where owners' corporations were seeking determinations from the board to retain some or all of the combustible cladding. And my firm, acted for the Victorian Building Authority, who was an interested party in those proceedings. So I was able to look at not just a number of fire engineering reports for the original design of the buildings that were being considered, but also the various cladding risk assessments that were prepared by fire safety engineers involved in those cases. So while I'm not a fire engineer, I have had a little bit to do with fire safety engineers in various roles that I've had, particularly in relation to the response to cladding. Okay, so legislative changes affecting the profession pretty much since, as I say, 2018. And I guess the main one is engineers registration schemes. So at the time that the Building Confidence Report was issued, there were only 3 jurisdictions, those that are highlighted in this table, where fire safety engineers were required to be registered. Since then, we have 2 new jurisdictions on board and 1 in transition. And so, as you can see from there, Victoria, whilst they had fire safety engineers as a registered practitioner category back then, they have replaced their scheme to the Professional Engineers Registration Scheme in 2018, which of course includes fire safety engineers. Interestingly, the Northern Territory does register engineers, but not fire safety engineers. And so far, South Australia has not registered engineers, although they have been out consulting and have said that they do intend to also introduce a scheme. So this is new for those engineers that weren't in the 3 jurisdictions that already had registration. What we're seeing is similar but slightly different schemes across our 8 jurisdictions, and Australia is very good at doing that, creating 8 different ways to do the same thing, which is, in my view, can cause significant issues for productivity. But what we've also had more recently is talk of a national registration scheme for engineers, and I've been told that there's significant interest in this from the federal government. And it might well also be related to the review of mutual recognition laws, which is currently underway by the Productivity Commission. So I think it would be great to see a national scheme for the registration of engineers, but my question would be, why would we just do it for engineers? As you may know, that the first recommendation in the Building Confidence Report was that we have consistent registration across the country, and I have always advocated for a national scheme for registration of building practitioners, something similar to what we do for the medical profession here in Australia. And I still think that that is one of the things that government should be looking at, particularly the federal government. But I guess if we start with engineers, if there is some genuine interest in that, at least that provides potentially a template for then introducing a similar regime for other practitioners. What I will say about registration schemes, though, is that they all heavily rely on Engineers Australia. Um, and in my view, under these schemes, EA has all care and no responsibility. Um, and what it means is, so the EA tends to be an approved assessment body that can assess applications for registration and look at competency and determine whether or not the applicant is suitable to be registered or have their registration renewed. But they have no role from a regulatory point of view. What it means is that with these models, the governments have basically outsourced the engineering knowledge and expertise to EA. In some of the schemes, there are other bodies that are also approved to do those assessments, but Engineers Australia has the vast majority of these assessments, competency assessments that they do. So if the regulator itself, so the government body that is issuing the registration, has no engineering expertise, it does raise questions about how effective these schemes can be in Australia. How would a regulation body assess complaints if they have no engineering expertise? And perhaps they can outsource it. Perhaps they can ask EA to assist with the assessment of complaints or investigation of complaints. But when we're sort of thinking about the activities of engineers, and this is not specific to fire safety engineers, but when we're thinking about engineers more specifically, not only do complaints really turn often around competency and whether or not engineering judgment was properly applied, that we need to make sure that those people assessing complaints have some engineering expertise in order to do so, in order to make determinations. And I really query whether or not we have that within the registration bodies. I'm not saying we don't have it at all, but these schemes tend to be very light on in terms of industry expertise within the regulator. The question there is what is happening with any proactive auditing of engineers, in particular fire safety engineers. And I have not seen certainly any evidence of that in Victoria, because what we do know, of course, is that the client of an engineer won't necessarily know whether or not the engineer has done a good job, unless something terrible goes wrong. But often we wouldn't know as a recipient of engineering services whether or not the services were acceptable. And unless there is proactive auditing to make sure that engineering practices are acceptable, then I query how well and robust the scheme is. I also question, if we don't have engineering expertise within these regulatory bodies, how do they know whether or not EA is properly performing its role in the accreditation of applicants? And so I think, on the whole, I really question whether these schemes are giving a ticket to play, but not really having the mechanisms in place to be also able to exclude those that are not competent or lack integrity. And the little graphic I've got there on the right is and the reference to it at the bottom, you can see that's the link to it. So once you get access to these slides, you can go out and try and find this paper if you like. But it's a paper that was written actually in the UK that was looking at registration of engineers in the UK, whether it was necessary. And one of the things that it highlights is that in order for a registration scheme to be effective, not only do you have to make the practice of engineering exclusive through requiring registration as a mandatory requirement, but you also have to have a scheme which is very good at excluding or kicking out those and taking away the privilege of holding that registration, to make sure that only those that are registered maintain competency and integrity and deserve to hold the ticket. And what I'm saying is that I'm not sure that our registration schemes in Australia for engineers have that second element in a way which is effective. And again, I'm not saying all of them. I'm saying that generally speaking, this is questions I think that need to be asked, particularly of these newer schemes that are being created, as to how not just the entry is being managed, but the exit, where there are complaints or through proactive auditing. And unless we have that, I think simply requiring engineers to hold a ticket is really only half of the battle in terms of ensuring that we have quality engineering practices in our country. In terms of other reforms, just looking at the building approvals process and the role of fire safety engineers in that process, we do know that because, and particularly now that we're required to have registration in most jurisdictions, that registered fire safety engineers are used where there are performance solutions on fire safety matters. But it's not mandatory to have a fire safety engineer on every building project, but certainly where there are performance solutions, they can only be done by registered fire safety engineers. But there are a couple of provisions in Victoria and New South Wales that go a little bit further than that, and that require that a certificate or declaration is made by a registered fire safety engineer. But that really only exists in those two jurisdictions, Victoria and New South Wales, as noted on the slide. So ultimately, the certifier or surveyor retains the ultimate authority to sign off. And I think it's open to discussion as to whether or not that's appropriate for fire safety issues, whether the RBS or the certifier should be the one to sign off on those issues. And certainly I have given some thought to whether there should be a parallel process for fire safety design and installation together with the general building approvals process. But in any event, so far we don't have that in our building approvals processes, and the certifier remains responsible with these couple of provisions that do call for sign off by a fire safety engineer. Independent peer review is another sort of interesting area. It's not mandatory anywhere in Australia, although it is in some cases used quite heavily on demand by the certifier or fire authority who requires peer review. Victoria has Ministerial Guideline number 4, which was reissued only recently last year. It had been in place since 2004, I think, the original version, and last year it was reissued, and it says that having regard to the complexity of design and building complexity criteria in the NCC, that the RBS may ask for a certificate from a registered engineer. So this is generic for engineers. It's not specific to fire engineers, but also require a certificate from someone that did not prepare the design. So, that's what we would otherwise know as a peer review, someone to look over the design to also certify that the design is compliant. So that is not a mandatory requirement, although it's often thought that Victoria does mandate peer reviews for structural and fire safety engineering. It's still discretionary, but the ministerial guideline is something that the building surveyor has to have regard to. I also note there the Society of Fire Safety guideline that was issued in relation to the assessment of combustible cladding in 2019. It said that peer review should be done on all cladding risk assessments, but I don't believe that that's necessarily been followed very closely, and I'll mention that a little later when I talk about some work I did to look at the role of fire safety engineers in the response to cladding safety in Victoria. Interestingly, the Northern Territory has mandated that for structural designs in certain circumstances that there must be independent third-party review. They're the only jurisdiction to have a mandatory requirement. And I think there is a real question about whether it should be mandated. Of course, in Recommendation 17 of the Building Confidence Report, we said that each jurisdiction should require genuine independent third-party review for specified components of design or certain types of buildings. And so whilst we weren't specific there about fire safety design, we certainly took the view that government should be mandating this in certain circumstances, and that has not yet been done, other than that one example there I've given in the Northern Territory. Oops. Okay. Um, the other area, I guess, where there's been some change would be in relation to mandatory inspections of fire safety system installation. We said in recommendation 9 of the Building Confidence Report that each jurisdiction should require a registered fire safety practitioner to design, install, and certify fire safety systems necessary in commercial buildings. And that was, I guess, what I mentioned a few moments ago, this idea that there ought to be almost a parallel process to building approvals that relates just to fire safety, that there ought to be fire safety practitioners of all different kinds throughout the process that are dedicated to the design, install, and certification of systems, both through registration but also through a process of mandating these sign-offs. And we did take the view that fire safety engineers should be on site inspecting to see that their designs are being installed correctly and signing that off. And New South Wales does require that there be a fire safety certificate issued before an occupancy permit can be issued by the certifier. And so that was something that was introduced a couple of years ago now. But it's still the case that not all fire safety system installers are registered. Of course, we have plumbers and electricians, but not other categories. Queensland, of course, in exception to that, they have quite a sophisticated and detailed fire safety practitioner regime, which does cover pretty much every type of fire safety system designer, installer. And so we've got pockets in the country where this is going on, but largely we don't have proper registration, in my view, or proper mandatory requirements for these sign-off at these different stages in the supply chain. Just looking at what the courts have said about the role of fire safety engineers, and we can't really do this without referring to the Lacrosse case. I'm going to assume, as an educated audience here, that you all know about the Lacrosse case. It is sort of their primary case around practitioner liability associated with the use of combustible cladding in Victoria, in particular in the Lacrosse building that was the subject of a cladding fire back in 2014. And essentially, that case concluded that fire safety engineers were part of the core chain of responsibility for compliance associated with the construction of buildings. And they apportioned liability for combustible cladding being on that building in the percentages as shown there. 42% was portioned to the fire safety engineer, 30% to the building surveyor, and 25% to the architect. Those percentages are the final percentages that were ordered in the Court of Appeal. They were slightly different in the original decision. But we do, this case stands as good authority, and my understanding, I don't practice in civil litigation, so I'm not involved in cases involving questions around liability and compensation for cladding. But my understanding is that many the insurers are heavily influenced by this case, and that many cases are negotiated based on the findings in this case. A lot's been said about the fact that the Lacrosse decision was quite fact specific, particularly in relation to the fire safety engineer. And that the particular contract that the fire safety engineer in this case had was quite unique. Other fire safety engineers say that they didn't have a contract which gave them as much responsibility as the fire engineer had in this case, and therefore that this case wouldn't apply in many other cases. I'm yet to find, and as part of preparing for this proceeding, I did go and have a look. I'm yet to find a case where it's been found that the fire engineer was not liable. So that's not to say that they are necessarily being caught up in litigation everywhere, but we don't have another decision since Lacrosse which has looked at these issues and taken a different view about the role of the fire safety engineers. So I think it is quite clear authority that fire safety engineers certainly had quite a large proportion of liability when it came to the use of non-compliant combustible cladding on the Lacrosse building. And the other case that I want to talk about is the recent Alucobond case. This is a mammoth case. It's over 500 pages long. I haven't read all of it, but I have read most of it. And it is quite a complex case. It involved about 21 days of witness evidence. There were 15 different expert witnesses, as well as then some other um, lay witnesses that were involved in the case. There were 9 barristers acting for the 3 parties. So one party had 4 barristers, another one had, well, in fact, 2 of them had 4 barristers. So that it was a very complex case. It was commenced in 2019, and the decision only came down last month. It was March or April. So it is a long and complex case. It was a class action that was brought by 2 owners' corporations, 2 different buildings in New South Wales, against 3A Composites and Halifax Vogel, who were respectively the manufacturer and the importer of Alucobond products into Australia. One of the owners' corporations involved was a 4-story building with a basement, 17 SOUs, and it had Alucobond PE installed on the building. In around about 2012, the occupation certificate was issued. The other building was, I believe, a 5-story building with 2 basements. I think it had around 30 SOUs in it. Sorry if I've lost the minutiae of the detail on that one. But the cladding on that one was installed a bit later, and you'll notice from the date 2018, that was after the La Crosse fire. And the cladding on that building was Alucobond Plus, which is one of the products that had 30% PE and 70% non-mineral core, so non-combustible core. So that one was installed a lot later, and after there was a lot more known, and after the sort of increased use of fire-resistant ACP products. What was argued by the OCs were that the products themselves were unmerchantable, that they were unsafe, that they shouldn't have been sold in this country. It was also argued that the brochures and other website promotional material for the products were misleading and deceptive, because they suggested that the products could be used on multi-story buildings in cases where, in fact, that would have been non-compliant. But the court said, and it's kind of given away here on the slide that's been sitting up now for a minute or two, the products were capable of being used in a compliant fashion, and therefore they weren't inherently unmerchantable or unsafe, as alleged by the applicant. There was quite a bit of focus in this case on who was the audience for the brochures and who were the people who were making decisions to use the products. And they created this term called the qualified professionals. And by that, they meant the designers, the certifiers, the builders, the installers of the product, including the fire safety engineers, to the extent that they were involved. And so they had this catch-all phrase called the qualified professionals, and concluded that it was the qualified professionals that did not comply with the law, not the product manufacturer and importer. They said that manufacturers such as 3 are entitled to assume that the markets into which they supply goods is a law-abiding one, and to the extent that the market is not law-abiding, consequences of non-compliance must fall on those who do not comply with the law rather than the manufacturer. I don't know what you people think of that statement, but I was kind of surprised that there wasn't, the courts weren't willing to attribute some proportion of blame to the manufacturers. Given what we know, I guess, about the Grenfell Tower inquiry and the behaviour of some product manufacturers and the way they tested products and other things. So, but notwithstanding that, this case was heard on the evidence that was put before it. There was lots of evidence about what each of the practitioners did or should have done in terms of the selection of these products, and the court concluded that it was really these qualified professionals that had dropped the ball here. Oh, sorry. in relation to the issues around the brochures. They were definitely there was a number of them. There was about 30 odd different brochures and websites that were referenced in the decision, and they were quite broad in their statements about the use of these products. They showed numbers of lots of very tall buildings that had the Alucobond products on them, and the applicants argued that this was misleading. Not only in a positive sense, but also that there was a lack of warning given or provided in these materials about when the products couldn't be used or shouldn't be used. So the court agreed that the products were very broad in their statements, but they also said that that was not misleading, because they said that the audience that we're talking about in this case are these qualified professionals, that they have an obligation and that their role was to assess the suitability of these products for buildings. They said that there was no evidence given that the pictures of buildings with Alucobond on them in the brochures were not compliant. And in fact, one of the experts was shown one of the photographs of one of the buildings in a brochure and said, can you express a view about whether or not the Alucobond was compliant on this building? And he said that would be impossible. I'd have to know a lot more about it than just looking at a picture. And so the court said, well, the brochures weren't misleading. The qualified professionals all knew that they would have needed to go away and ask for test reports and put together a bunch more information about the proposed building in order to decide whether this product was suitable for use. And therefore, it was really, again, on the qualified professionals to do their jobs, to perform their roles and ensure that the product would be suitable for the building, as opposed to the manufacturers who were offering their products for sale. On the question of whether there was a failure to warn, and this was put by the applicants, that the manufacturer and importer had a positive duty to describe in the brochures or in their promotional material when the product shouldn't and couldn't be used. And the court again disagreed and said, had the qualified professionals been acting competently, they would know that they couldn't just rely on the brochures, that they wouldn't need to be given these warnings because they would have done their own due diligence on the products and their suitability for use. And it was up to them to make all the necessary inquiries, not up to the manufacturer to offer warnings. So the applicants in this case, the two owners' corporations, lost comprehensively in this case. Now, it was a single judge. I don't know whether or not the case has been appealed. If it were appealed, it would go to the full federal court, and there'd be multiple judges that would review the decision. So who knows whether that will happen, but it was a class action, and at this point it has failed in trying to hold to account the manufacturer and supplier. I'm a little troubled by this decision. I think our chain of responsibility laws, to the extent that they exist in Queensland, do put obligations on manufacturers and suppliers. I think governments need to seriously think about this decision and whether what has been held here is what we want to be the case in terms of the responsibilities on manufacturers and suppliers. I'd like to think that we should tighten up, what should be in product information and what obligation is there to provide warnings about products or clear information about the limits to which they should be used. And I guess from my part, and watching what has gone on since the La Crosse and Grenfell Tower fires and the consequences of all of this, I do think that the manufacturers and suppliers of these products had substantial knowledge about their products being used inappropriately, and there should be some accountability brought to them. But hey, I wasn't the judge, and there was lots of evidence led in this case, and that is the current state of the law in Australia. So I'll be very interested to see whether governments move to create some legislation that shifts what is essentially the outcome in this case, that product manufacturers and suppliers have no accountability when it comes to the promotion of their products for use in the construction of buildings. I guess the other big change that's happened, of course, is the New South Wales Statutory of Duty of Care. So whereas, under lacrosse, there was considerations of negligence or breach of contract and these kinds of concepts, since that decision, we now have Part 4 of the Design Building Practitioners Act, which says that a person who carries out construction work, noting that that provision is incredibly broad, has a duty to exercise reasonable care to avoid economic loss caused by defects in or related to building work for which the building in or related to a building for which work is done and arising from construction work. So the duty is owed to owners and subsequent owners, including owners' corporations, and it applies to all practitioners in the supply chain, including designers. It is a non-delegable duty, and that term was considered in detail in the High Court in the case of Fafburn, where the court said that the developer and builder could not use the proportionate liability regime to bring other practitioners into the proceeding. So we have this obviously only applies in New South Wales. A lot of the other jurisdictions are watching to see whether they should introduce it. We don't yet have it introduced in jurisdictions that have had recent reforms. So, for example, Victoria's done a significant overhaul and is still in the process of doing a significant overhaul of its legislation and its consumer protection laws, and it has not introduced the statutory duty of care here in Victoria. It's done some other pretty significant things, but this does change the framework. And I guess for those on the call today who are practicing in New South Wales, you might like to comment on how it has changed the way you practice in New South Wales. I certainly think that the insurance industry doesn't look at individual jurisdictions, they look at our country, and that this statutory duty of care would change the way insurers think about their policies for practitioners, given this statutory obligation. It's being used extensively in New South Wales, and it is very clear in its intention in terms of the duty that is on the different building professionals. Turning now to look at political and market forces and how that affects the role of the fire safety engineer. The little image there on the side is one that I looked for to try to represent this concept of the race to the bottom. It's alive and well in the building industry and in all areas of the building industry. And I would expect that most of you on this call would that concept of race to the bottom would resonate with you in terms of the competition in the market and the way in which some of your colleagues go about trying to get work and offering to do less for more, or undercutting quotes and other things. So it is there right throughout the industry. I think there is a strong awareness amongst the fire safety engineering profession that holistic design is required, and that is the role of the fire safety engineer. And I think that realization has come over the last 10 years or so. The work done by the Warren Centre back around 2019, 2020 really reinforced that, and any competent, capable fire safety engineer that I speak to is, very clearly understands that their role is to assess fire safety on a holistic basis for the building. The question is, how do you get the market to ask for that and pay for that work to be done? And I think that is the ongoing struggle for the profession. I've heard very similar concerns raised by architects and other design professionals. This is not a problem that is isolated to fire safety engineers in terms of trying to be paid for and given a scope of work that really allows you to fully address and meet your obligations as a fire safety engineer. Again, in New South Wales, the Design and Building Practitioners Act was introduced, and it requires not just the statutory duty of care provisions that I've just mentioned, but also that the designers must declare that their designs are compliant, and that was intended to improve the adequacy of design documentation and to essentially reset the value proposition for designers to be able to say, these are the new requirements. I now need to be paid X in order to deliver you with a set of design documentation that I'm able to declare as compliant. And it was definitely and deliberately intended to arrest the race to the bottom and to lift the quality and adequacy of documentation in the building process. Again, I'd be interested in those of you on the call from New South Wales as to whether this has happened. That Act does only apply to Class 2, 3 and 9C, so it's not broad-ranging across all construction. And there's also been a number of people come out and say that it's led to significant increases in cost, which the market cannot bear and which, potentially bears some responsibility for viability of projects and housing supply issues. So there's plenty of people who will debate the benefits or otherwise of these reforms in New South Wales, but these are sort of market forces or reforms that are intended to influence the market and to enable better quality design documentation, including from fire safety engineers, and give them the opportunity to do more holistic assessments rather than just being given a list of areas where performance solutions are needing to be developed. The other sort of report that I mentioned a little earlier in this presentation was one that I did recently. So it came out in December last year, where I was commissioned by Cladding Safety Victoria to look at the role of the fire safety engineers in response to combustible cladding in Victoria as part of CSV's program. And we know that the response to combustible cladding has varied across Australia in terms of what government support has offered. But in every jurisdiction, the role of the fire safety engineer in cladding risk assessment work has been critical. And all governments have really relied on your profession to assist to resolve what has been a significant safety risk in the community. Some observations from that report. We looked back at the Warren Centre work because that was done back in 2019, which was around about when Cladding Safety Victoria was created. And, it said back at that time that fire safety engineers had limited expertise in risk engineering. And we certainly found that. And in our work to produce this report, we met with a number of fire safety engineers who all agreed that when this crisis emerged, there was limited expertise in doing fire safety risk engineering as opposed to fire safety design. And so there was a real struggle for the profession to efficiently provide consistent and rational cladding risk assessments, certainly early on, and some would argue that that continued for quite some time, or may even still be the case. I think there are a range of different levels of competency in this profession, both in terms of design and in terms of risk engineering. What we found in this review was that the fire safety engineers resisted the attempts by government to develop a much needed rectification standard. We also found that the standard could not have been prepared early on because it was informed by an enormous amount of research and knowledge that was gained from the program itself. And so while those early attempts were resisted by the fire safety engineers who were telling government that this couldn't be done, were probably sound, as time went on, that continued resistance against government developing and issuing a standard sort of became unreasonable. We found that the fire safety engineers really misunderstood conflict of interest. There were way too many instances. In fact, there would be, what I concluded in the report was that there would be very, very limited circumstances where a fire safety engineer could properly accept a client asking them to do cladding risk assessment in circumstances where they had also been involved in the design of the building, and that this was occurring frequently. And in fact, as we were doing this report, the Building Appeals Board issued a determination where they highlighted that the fire safety engineer involved in that was quite conflicted because they had been involved in the design. So there was sort of real life examples being aired in that context as well. There was inconsistent use of peer review. I mentioned earlier the SFS guideline for cladding risk assessments said that there should be peer review in every case. That guideline was being used under the program, and yet there was very inconsistent views from the fire engineers about whether or not it was needed, and whether they insisted on it or whether they just left the client to decide whether it should be done or not. And so this whole concept of peer review seems to have quite mixed views from practitioners in terms of supporting and encouraging it. But there was an inherent tension between bespoke assessments and CSV's mandate to deliver cladding across, hundreds of buildings. CSV did eventually issue a rectification standard through what we call a Victoria MG15 ministerial guideline, and it was based on the cladding risk mitigation framework issued by the Victorian government. We concluded in the report that most fire safety engineers had refused to engage with MG15 and CSV's framework. And the MG15 did say that it was ultimately directed at the building surveyors and at MBSs, and that they had a discretion, as well as the ability to have regard to the framework, or the obligation to have regard to the framework. And that created a bit of confusion about whether the framework was mandatory and whether even the fire engineers had to apply it. So we said the government really should have been clearer in terms of that, but notwithstanding that, it was not appropriate for fire safety engineers to ignore it and refuse to apply it, and in some cases actively undermine its use out in the market, which we found evidence of in the review. A couple of the observations, we said that CSV could have consulted more with fire safety engineers during the development of this framework, and that failure to do so contributed to significant animosity. We also found, though, that there were these criticisms about MG15 and the cladding risk mitigation approach. We tried very hard to tease out what they were during this review and to have people explain them to us so that we could interrogate whether or not the framework itself was flawed, and we were unable to discern any clear and concise and feedback and criticism. Everything was quite vague, and when we pressed for more information or examined what the criticisms were, they just seemed to be unfounded. So that was sort of where we landed on that report, and I won't say much more about it for the purposes of today unless anyone's got a question. Now, for the final sort of section of this is, what is the future of fire safety engineering in Australia? We've talked about a number of issues that have arisen. I'm a glass half full sort of person, and I'm sure we've got a mix of you in the audience, but I do think, as I mentioned earlier, this profession is critical, where we need fire safety engineers. They're not going anywhere, and the profession really has to rise to the challenges and the market forces that are there. I think there are some key issues, and I think really the profession needs a roadmap. And how do you develop one of those and commit the profession to it, and then embark about implementing a roadmap is the real question for the profession. I think some of the issues that have arisen and which have been commented on by the courts and in my CSV report really go to the issues around competency and integrity. But again, that is not particular to fire safety engineers. I think, when people ask me, or in the past asked me, what was the building confidence report about, I said really it boils down to competency and integrity in our building industry across the board for everybody. So it is, if we could have a bit more of both, not just out there in the market and with the stakeholders, but also in government, I think that would be amazing. And I think that's where some focus needs to be. There needs to be leadership in your profession. Certainly there are comments in our CSV report which really question the leadership in some of the professional associations that we dealt with for that report. Role clarity here, what is your role vis-a-vis the building surveyor, vis-a-vis other design practitioners involved in the process, and how do those roles integrate appropriately? And using your seat at the table. There does need to be some reform. Certainly the recommendations we made in the building confidence report that go to the role of fire safety engineers and other fire safety professionals have not been introduced. There might well be some advocacy that needs to be done around these competency issues in terms of courses and more availability of courses, the quality of courses in Australia. All that needs to be done and done through good advocacy with government. Finally, I'll just note that as part of the BCR work, I was involved in the preparation of a code of conduct for fire safety engineers. No jurisdiction has picked this up. There's a couple of clauses that I've pulled out there for you, but I do think that one of the key things that needs to happen for this profession is that we need to develop and publish either a code of conduct or some sort of practice standard, which is very specific to the role of fire safety engineers and clearly sets out what the obligations are of a fire safety engineer and these ethical and integrity issues that are essential to the proper practice of fire safety engineering. Codes of conduct, I think, are a good way to do it, but they shouldn't just be motherhood statements, which is what a lot of codes of conduct are. I think they need to really give good examples of what is and isn't appropriate conduct in a fire safety engineering context. And there are examples of practice standards in New South Wales that have been issued for building certifiers that really, I think, have been quite significant in terms of trying to signal to that profession what it is they need to do differently in order to properly discharge their duties. And I think we probably need the same for a number of different practitioner groups, but certainly for the fire safety engineers. I'll conclude there.
Thank you, Bronwyn, for that great presentation. I thoroughly enjoyed it, and I can tell by the engagement in the chat that we have many questions for you. I'm not sure if you're able to see the chat function and maybe start answering out some questions. If anyone else still online wants to ask any questions as well, feel free to unmute yourself and ask Bronwyn.
We're just doing it through the chat, so I'll just have a look at these questions.
Sure.
New South Wales, why doesn't your table refer to the registered certifier fire safety requirement under the BDC legislation? It is registration required to practice as a fire safety engineer. Yes, of course, the registration required to practice. So yes, I'm not sure what was missing from the table, but you certainly need to be a fire safety engineer in New South Wales in order to practice for regulated work, that is. Only 4 engineers subject to VBA's disciplinary proceedings in 10 years. Technically, only 2 relate to their engineering work, and they're the lacrosse fire. So the comment around engineers in Australia is on point. All care, no responsibility seems to also follow. Yeah, I agree. The CSV report, we looked at the disciplinary hearings that have been held against people involved in combustible cladding installation, and it was pretty low. We also looked to see whether Consumer Affairs Victoria, which is actually the regulator under the new professional scheme, has done any enforcement, and we couldn't find any. No cases in VCAT. There seems to be, and that really led to the conclusions that I've made, that these schemes are really lacking in that element of compliance enforcement and audit. They seem to just give a ticket to play and not actually a regulation of engineers in any meaningful way.
I've noticed also in Queensland, the BPQ sends out a quarterly newsletter, and I think maybe I've seen once or twice in my 4 or 5 years of being a chartered RPQ that they've actually taken action against someone, and that could be not necessarily even a fire safety engineer. So I think we have the same problem in Queensland too.
Yeah, yes, that's quite possible. Although, I mean, people do say the Queensland model is the best and it's effective and those kinds of things. So, look, I don't know enough about it. I know it has been around for a long time and it is sort of hailed as the model. I still think that we can do something a little different. And the architects model, I think, is a really good national model for a group like architects, and perhaps that is where it should go. I've written more about this in the CSV report for those who are interested. Yeah, so there's a question on here about the Alucobond case and the test reports. There is some commentary in the decision about test reports and about the manufacturers being quite deceitful in the way they created the test rigs and other things. And I guess the issue with that is that what the experts said about that was that, well, as experts, when we look at test reports, we ought to look at those objectively and identify that the test rig is of a certain configuration that may or may not reflect the building that we're proposing to use the product on. So again, the experts themselves kind of said, yeah, look, these manufacturers can bluff in their brochures and put out test results that are dodgy, but our job is actually to look behind all of that and interrogate that. And so in some ways, they shot themselves in the foot because they were kind of saying, yeah, we're used to that. And it's our job to actually look very closely at those test reports. So even though they were acknowledged in the judgment as being I think one of the experts said that it was appalling the way that the test reports were passed off as doing or demonstrating things that weren't true about the products, that the court didn't didn't really take that up in terms of, which is why I think that we really need to think about that decision, and is that what we want in this country, or do we want more accountability for manufacturers? Yes,
Just,
and
just,
yep.
just to, sorry, follow up on that question. I know that's sort of an outcome of the Grenfell Tower inquiry that they have these test reports. They often, but product manufacturers don't want to share their test data for commercial
Mhm.
reasons. But then these tests actually don't. They just provide sort of a ranking system. They don't give us actually meaningful data. So, I guess, are you aware of any sort of changes within government to actually look at changing the way we test standards and the accountability of manufacturers to actually provide data and test reports?
Unfortunately, Josh, the governments aren't really listening on this. I did a report for all Australian governments in 2024 on how we should enhance building product regulation. And I was specifically asked not to give them advice on our conformity assessment regime,
Okay.
which was a little disappointing. And the argument was that they were already doing a review of code mark and conformity assessment, and therefore it didn't need to be in my report. But I'm not aware of any review that's come out, and I do think our conformity assessment system is underdone. I read on LinkedIn just this week that there's moves to get rid of the Cyro testing facility in
Yeah.
Northside. I mean, oh, please speak up, everybody, about that. That is such a backward step in a system where we already don't regulate products closely enough. So yeah, there's so much that needs to be done from a regulatory perspective, and I'm disappointed with the Alucobond decision. I think it doesn't help at all, and governments need to step in and legislate in response to that decision, in my view. Um, I'm mindful of the time. Do you want me to keep going through the questions, Josh?
If you have time to, I'm more than happy for you to, as long as you,
Okay.
up to you.
What exclusions should we have in our contracts to protect fire engineers from unreasonable liability? Um, yeah. Well, unfortunately, I don't think, as much as I've said what I've said about the Alucobond case, I agree with the lacrosse decision, and I don't know whether the liability is unreasonable. I think what's unreasonable is that you're under a lot of pressure to deliver a product that doesn't allow you to do holistic fire safety assessment. And the problem is in the market. Now, I think you can protect against that by ensuring that your contracts and your scope of work is clearly defined. The trouble with that is that you run into that flies in the face of trying to change the profession or the market to understand that you actually need to do things in a holistic way. So this is one of the central problems for you as a profession, is to create your value proposition and to make the stakeholders understand that you need to be able to be paid to do your job properly, and not just be responsive to some checklist of performance solutions that you are to produce on demand. And until we can sort of change that, and if there's a legislative way to do it, then I'm up for trying to think one up. But the problem here is the market. So yeah, your contracts, sure, try and limit that scope, but all that's doing is really maintaining the status quo, and that is that you're not being allowed to do your job properly, and we're not getting the full input from fire safety engineering that we need in the design of buildings. Um, yeah, there was a practice guide for engineers in New South Wales that I was aware of that did get shelved. I I don't know whether it had very much in it that was specific to fire safety engineering, whether it was for engineering more generally. But again, it's what I said towards the end of my presentation, that I think one of the key issues in terms of the way forward for this profession is to commit to a practice standard or a code of conduct that is detailed in some way, that that can be sort of published and adopted by governments even, in terms of what's required, because you'll then be able to, and this did happen with building surveyors post building confidence report. There was, Victoria didn't have a code of conduct. It issued one, and it allowed sort of a recalibration. Building surveyors were able to show that to their clients or prospective clients and say, I can't sign up to this scope of work because it doesn't cover all the things I have to do now under this code of conduct. So I think these documents can be really useful, particularly if they're issued by governments, but obviously you need to be at the table in terms of what goes in them. But I really think that these are critical to, if this is mandated in legislation that you must do holistic design, then you can't be engaged to do something less than that. And that's how you sort of change the market forces, I suppose. So I think you've got to be open to governments creating these practice standards, even though they might sort of challenge you in terms of what you're doing and whether or not you see them as reasonable, because they will, if they're done well, shift the way that you provide your services. Glass is half full. Great. Thank you. We want more of that. I mean, despite, I guess, the CSV report and my criticisms of your profession in that report, um, don't take it personally. I wrote about what I found and what my views were. But this is a really great profession. I know a lot of you, and I know that there are really great people. In fact, that's what gets me out of bed every day, is the people who want to do better, the people who do have integrity, and who are constantly dismayed by the compromises that they're forced to make because of the way the market works. So please stay glass half full and look at this as a positive opportunity. Yep, similar discussions on fire safety engineering happening in the UK. Yep, I'm not surprised there. I'll have a look at that link. Thank you for that. Um, we can't limit our scope through contracts. That's a utopian statement. We need to lean in and move towards holistic design. I agree, Chettle. We certainly do. I agree. And yeah, I absolutely agree. And if all of you refuse to do that, then hopefully we can rise the tide rather than uh, and arrest that race to the bottom. I agree completely. That's all of them, and it's 5:03.
Excellent. Well, thank you very much, Bronwyn, for your time. It's been a very informative presentation for myself and hopefully everyone online. So yeah, I'd just like to thank you again for your time, and thanks to everyone online for attending. Hope you got something or many things out of it. So yeah, thank you again.
Hi, Brian. Thank you, everybody. Oh, that's so
Uh,
cute. Thank you.
thanks all for joining, and hopefully we'll see you next time.
Great.